Federal judge suspends key provisions of New York's new gun law.
The U.S. Supreme Court has just issued a major ruling in the challenge to a New York gun law.
New York State will be raising the age to buy semi-automatic rifles to 21.
The law prohibits the possession, manufacture, or sale of semi-automatic rifles and high-capacity magazines.
To hand down a decision in the coming weeks when it comes to the state's concealed carry law on whether or not that is constitutional.
The New York State Rifle and Pistol Association went to court today to try to block that provision, saying it's unconstitutional.
The contentious rifle and shotgun permit restrictions in New York were to be immediately blocked, but the Supreme Court just denied emergency review in this case. Surauer versus City of New York. The case we'll be discussing in this video is called Surauer versus City of New York, and it involves a challenge to the city's application process, which essentially requires residents to first apply for a permit in order to be able to acquire rifles and shotguns within the city. One of the main issues with the permit requirement is that it is purely discretionary, meaning that the police department in the city of New York gets to determine who can legally possess and acquire these types of arms. The police department assesses whether an individual meets the good moral character determination. Presently, this case involves a permit scheme that in some ways is in direct defiance of what the Supreme Court recently ruled in the New York State Rifle and Pistol Association versus Bruen case. The plaintiffs argue that under Bruen, the Supreme Court struck down a similar application process that was purely discretionary. The Supreme Court found in the Bruen case that there was no historical support for a may-issue CCW licensing permit scheme. Now, the plaintiffs in this case argue that there is no historical support for a may-issue arms possession permit, which is the system currently in place in New York City. This entire lawsuit sprung up because of the Supreme Court issuing the Bruen decision. In Bruen, the Supreme Court struck down New York's may-issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition.
Federal judge suspends key provisions of New York's new gun law.
New York lawmakers have approved a sweeping overhaul of the state's handgun licensing rule.
New York will prohibit the sale of body armor for civilians, require a license to purchase semi-automatic rifles.
The Supreme Court handed down this decision, which will undo a different law. Now,
is unconstitutional and restricts their Second Amendment right to bear arms.
One of the primary findings of the Bruen decision was that the government bears the burden to prove that their restrictions are based on the history and tradition of our nation. In Bruen, Clarence Thomas, writing for the majority, stated that New York's proper cause standard was invalid. He went on to state that the burden falls on the respondents to show that New York's proper cause requirement is consistent with the nation's historical tradition of arms regulation. Only if respondents carry that burden can they show that the pre-existing right codified in the Second Amendment and made applicable to the states through the 14th does not protect petitioners' proposed course of conduct. So that's the backdrop of the Bruen decision, which rejected the use of the proper cause standard and similar good moral character standards in the granting or denying of concealed carry permits based on those discretionary standards. In this case, the plaintiffs are using the Bruen decision to attack a good moral character requirement that is now being used to approve or deny permits to own, possess, or acquire these types of arms. This case was brought by the plaintiff Joseph Surauer, who challenges the constitutionality of New York City's discretionary licensing scheme for the purchase and possession of rifles and shotguns. On review, the district court granted a permanent injunction against the provision of that scheme that required individuals to prove they are of good moral character before being allowed to purchase or possess arms.
The U.S. Supreme Court has just issued a major ruling in the challenge to a New York gun law.
Hired an individual who wanted to carry a concealed weapon, a concealed handgun.
A major ruling involving the Second Amendment. The Supreme Court struck down a New York law.
New York's new gun registration law is about to kick in.
But here in New York, we don't wait. We lead. We've already have the strongest laws in the nation.
This was a significant win because a lower federal court found that this type of permit scheme and the good moral character standard were improper. However, the city of New York quickly filed an appeal to the Second Circuit, which is known for its less favorable stance on Second Amendment issues. New York also sought a stay on the permanent injunction while the case is being appealed in the Second Circuit. The Second Circuit granted that stay in favor of the city of New York. An emergency application was then filed to the Supreme Court asking for it to step in early on an emergency basis to remove the Second Circuit stay. The two main arguments presented to the Supreme Court for removing the stay were that the state of New York would not win their appeal. The argument was that the lower court had already ruled in favor of the plaintiffs, finding that the good moral character standard violated Bruen and the Second Amendment, and thus the city of New York was likely to lose on appeal.
The 10 new bills will strengthen the state's gun laws.
Applicants will have to show they understand how to use a gun, and they'll have to safeguard it when not using it.
Proper cause requirement that the NYPD uses to determine if someone is eligible to receive a carry permit.
Trying to put a hold on new Illinois law that would ban high-power semi-automatic weapons.
Therefore, the Supreme Court should step in and remove the stay issued by the Second Circuit. Additionally, there was an argument that the Second Circuit is relying on the Antonyuk case, which involves concealed carry handgun licenses, but this reliance is incorrect. The plaintiffs pointed out that Antonyuk is not binding on appeal specifically for this issue because it dealt with a preliminary injunction and not a merits-based determination like in the Schroer case. Supreme Court denies emergency review. This appeal in Schroer is essentially a merit review. It truly is a merit appeal. Antonyuk is still in an interlocutory posture and is dealing with a preliminary injunction. One of the interesting aspects of this decision and the use of Antonyuk in the Schroer case is that the Second Circuit stated that Bruen was an exceptional case, but Antonyuk is not, and some of these other cases, like Schroer, are also not exceptional. As a result, the Second Circuit claims it does not have to follow the Supreme Court's ruling in Bruen. That's one of the very interesting developments in Antonyuk, and the argument here is that the Second Circuit relying on Antonyuk is still a failure. It's wrong. It's an error. This kind of proof shouldn't have been used in this particular case, and the Supreme Court ought to intervene right away to put an end to this kind of disobedience. This emergency application was originally filed with Justice Sonia Sotomayor, who is the justice responsible for reviewing emergency filings that come out of the Second Circuit.
Jennifer Johnson looks at what the new rules mean for New Yorkers and how the state's governor is vowing to fight back.
This comes after the U.S. Supreme Court struck down New York's restrictive handgun laws, which required a good reason to carry.
The Supreme Court today said you can't require someone to justify why they want to conceal carry a gun, but it was leaving open.
The core reason for the Second Amendment is to provide law-abiding citizens with the ability to carry a gun for self-defense.
New York State will be raising the age to buy semi-automatic rifles to 21.
Back on April 4th, Justice Sotomayor denied the emergency application on her own. She did not submit it to the full court for consideration. Usually, what happens with these types of emergency applications is the justice responsible for that area will submit it to the full court for consideration, but she denied it on her own. What that meant under the Supreme Court's rules is that the plaintiffs, in this case Joseph Schroer, could then go to any of the justices and submit a new renewal application for consideration. That's exactly what he did. What ended up happening is that Justice Thomas accepted the application and then referred it to a full court conference for consideration on May 16th.
The law prohibits the possession, manufacture, or sale of semi-automatic rifles and high-capacity magazines.
Make threatening mass harm a crime and will strengthen the state's red flag laws.
The U.S. Supreme Court has once again been asked to block Illinois' assault weapons ban.
The Protect Illinois Communities Act bans dozens of specific brands or types of rifles and handguns.
The New York State Rifle and Pistol Association went to court today to try to block that provision, saying it's unconstitutional.
After May 16th, this Schroer case went to the Supreme Court for conference along with a bunch of other Second Amendment cases, like the Bianchi, Maryland attack weapon ban case and the Illinois rifle ban cases. We were waiting to see what would happen, and this week we got an order list from the Supreme Court. Unfortunately, they denied emergency review in this case and in the Bianchi case. You may be asking yourself, what does this mean and where does this leave us? Is this case dead in the water now that the Supreme Court has denied the emergency application? The answer is no. First, Keep in mind that the Supreme Court does not traditionally like reviewing these types of cases, especially when they are seeking a reversal of a stay order. These are unusual emergency applications that the Supreme Court does not like to review. They prefer final merits reviews and circuit court splits, and that's traditionally when they will review cases. Here, there was this in-between stay order issued by the Second Circuit, and the Second Circuit is still going to review this appeal and issue their own merits determination.
The legal challenge is now aimed at one of those proposed concealed carry rules and regulations.
Among others, the new rules take effect September 1st and apply to new and existing applications for a permit.
A government figure, that the individual had a particularized need for that concealed carry permit.
But we view them as only temporary setbacks, and I refuse to surrender my right as governor to protect New Yorkers from gun violence.
To hand down a decision in the coming weeks when it comes to the state's concealed carry law on whether or not that is constitutional.
The Supreme Court likely decided not to get involved right now, preferring to let the Second Circuit issue their own merits decision and then reconsider the case at that time. As you can see, there's still a lot of development left in this case, and that's probably why the Supreme Court decided to punt on this issue for now. Another thing to consider is the fact that currently we are waiting for a new Supreme Court decision regarding the Second Amendment, specifically an opinion on the Rahimi case. We are waiting for a decision in Rahimi, which seeks an application of Bruin to a federal law regarding domestic crime restraining orders. This has huge implications for many other Second Amendment cases. The Supreme Court's current mindset may be to punt all these cases right now, wait for the Rahimi decision, and then see where the chips fall. They might prefer to let the lower courts apply Rahimi instead of stepping in before Rahimi and dealing with potential complications afterward. They might issue their decision in Rahimi and then see how the lower courts deal with it. So while this isn't great news, the Sarower case is not dead in the water. We will just have to wait to see how the Second Circuit rules. That's all for this video, folks. We'll see you next time.